everybody, welcome and thank you very much for joining us in this webinar to discuss our consultation on a proposed new competence statement for solicitors. My name is Julie Brannan and I'm the Education and Training Director at the SRA, and I'm joined by my colleague Mary Costello, who's a researcher, an education researcher at the SRA.
Hello everyone.
This is an interactive webinar. You'll be able to ask questions as we are speaking, and we'll pick up those questions at the end of the presentation part of it. To ask a question, please just click the Ask a Question button at the bottom of your screen. And if you are having any technical issues, please click the Technical Support red button on your screen to request assistance. As well as there being an opportunity for you to ask questions of us, we have some questions for you on which we'd like you to vote. And when we get to the questions, they'll pop up on your screen, and to vote you just click on the relevant button. So, training for tomorrow. Before we get to looking at the competence statement that we put together, I thought it would be helpful to take a moment or two to look more broadly at what we're proposing and why we are undertaking a review of education and training for solicitors. What is it that's broken that we're trying to put right? Historically, what we did and what we continue to do at the moment is to prescribe learning. We specify particular courses for people to take, and we delegate the assessment of those courses to a wide number of individuals. We commissioned some research which was published in the summer of 2013, and that was undertaken independently by the Legal Education and Training Review. And what that told us was that this concentration on prescribing learning needed to shift. We needed to focus better on assuring standards rather than prescribing particular courses or particular steps that we say have to be taken in order to, we hope, meet those standards. So our objectives are to shift our focus to assuring standards, and by doing that, to remove barriers which are created through specifying particular pathways, and we hope therefore to encourage the creation of new, flexible and innovative ways to qualify. And we hope by doing that, that first of all, we will assure that solicitors who qualify are competent to practice, so that the public are protected, and also that the best people who have the right ability to be a good, safe solicitor are able to qualify, and that those people are not put off through things like the cost of qualifying, the cost of our qualifying processes. So that's a little bit about the context for our work. Let's move now to the first question.
Okay, so before we move into looking at the competence statement consultation, we thought it would be helpful to get a bit of a sense about how many of you have had a chance to look at it. So if you could tell us, have you had a chance to read the Solicitor Competence consultation document before today's webinar, and if you could select that option there. So have you had a chance to read the Solicitor Competence consultation documents before today's webinar? So if we look at the results now and see how many of you had the chance to do that. That's there. Okay, so around about a third of you, 29%, have had a look at it, and 71% have not had a chance. So that's going to be really helpful now today to talk to you about this, so we'll move on to looking at the competence statement consultation.
And just to remind everybody, the consultation closes on the 12th of January, so there is still plenty of time to have a look at it, and if you wish to get in a response to the consultation. So I was just saying before that question about how our work as a regulator was shifting to assessing standards rather than prescribing particular pathways for people to meet those standards. We have the work that we're undertaking as part of our Training for Tomorrow programme of work has two steps to it. First of all, to define the standards for practice as a solicitor. So we set ourselves a task to set out what the standard was that was required for people to practice safely, effectively, competently as solicitors, so that the consumers of legal services were protected. And that is the work that we have done in producing the documents that we're consulting on at the moment. As we shall see later on in this presentation, the next step is to think about how we assess those standards, in particular at point of qualification. And that leads us to the consideration briefly about the function of the competence statement. As we will see when we look more closely at it, the competence statement is a generic statement of the competencies required for practice as a solicitor. It has no level in it, so it applies equally to practicing solicitors and people who practice for many years as to newly qualified solicitors. So its function, so far as we are concerned, is that it sets out the competencies that people who wish to qualify as a solicitor must be able to demonstrate in order to be admitted, but it also sets out the competencies which must be maintained throughout a solicitor's career. So it has that dual function. We're consulting on 3 documents. So there are 3 documents which are attached to our consultation paper. First of all, the competence statement itself. Secondly, a statement of underpinning legal knowledge. And thirdly, a threshold standard. And I'll explain each of those documents in turn as we go through this presentation. But taken together, they constitute a new definition of the standard required for practice as a solicitor. Now, this standard hasn't just come out of our head. Over the past 12 months, we've undertaken a very large-scale piece of research to identify what it is that people need, what are the core activities that solicitors need to be able to do, and what the evidence base is for those. We've undertaken qualitative and quantitative testing, both of solicitors, a wide range of solicitors, and also consumers of legal services, both interviews and online questionnaires, and the consumers we spoke to were individual consumers and business consumers. So there's a lot of work went into that. We've also undertaken a series of workshop groups where we have spoken to people more broadly about the work as it's being developed. We've taken successive drafts to those people so they had an opportunity to comment on successive drafts. And our work throughout the whole process has been guided by a Delphi group of experts who are all people who have experience in developing professional competence frameworks, either in a legal context or in other regulatory and professional contexts. The competence statement has already been tested, as I said a moment ago, through interviews and an online questionnaire on a large number of people. So not far off 2,000 people have already taken a look at the draft which we have put out for consultation. And this is what they thought of it. It's a slightly complicated sentence. It comes from the research report that the research organisation who we commissioned to undertake the questionnaire gave to us. But what it means in essence is that 87% of solicitors, 87% of individual consumers of legal services, and 90% of business consumers said that they thought the competence statement or rated the competence statement as at least 7 out of 10 on a 10-point scale where 1 was low and 10 was high. So that gave a reasonable comfort to us that most people who looked at the draft felt that it was it reflected adequately the competencies that are required for safe practice as a solicitor. So that's our evidence base, and that's the feedback that we've had on it so far. How is it structured and what does it say? We've taken an activity-based model. So the competence statement does not set out the knowledge, skills and attributes that are required for safe practice as a solicitor. Instead, what it does is it identifies the core activities that we say all solicitors should be able to undertake. And the reason for this is that we are not interested in what particular makeup of skills or knowledge go into a competent activity. What we're interested in is that the activity itself is effective. Many of you will be familiar with different balances that people have between carrying knowledge in their head or having to look up a particular piece of knowledge or piece of information. And this is an example of how for one person they rely on their research skill, another person might rely on their legal knowledge in order to answer a particular question and advise a client competently. As I said a moment ago, we as regulator are not concerned with how somebody has reached the right answer. What we're concerned with is that the advice which is given is accurate and the client is competently advised. So that's why we chose the activity-based model rather than saying you have to have these particular skills or this particular knowledge in order to perform a particular activity. As I also have said, the competence statement is generic for all solicitors, so it applies to all areas of practice and it applies to all degrees of qualification, both those who are newly qualified solicitors and those solicitors who have been working for many years. And we've explained this in the little preamble which I've put up on the slide, which is at the beginning of the competence statement, which makes clear that competence is a dynamic concept. It changes from day to day and as job roles change and as area and context of work changes. What this means is that it is for individual solicitors to take our generic competence statement and apply it to their particular area of practice to see what it looks like for you in your day-to-day work. However, we did feel that there were core activities that applied to all solicitors. And that's what this competence statement seeks to capture. It's divided into 4 broad domains: ethics, professionalism and judgment, technical legal practice, managing yourself and your work, and working with other people. Those are not listed in any particular order of importance, except that we did very consciously put ethics right at the start of the competence statement, because for us it's a matter of particular importance. And also when we talked to solicitors and when we talked to consumers of legal services, it was something which was important for them too. So ethics is advisedly at the start, but apart from that, the various activities are not in any rank order. And within each core activity, we have divided the activities into particular critical factors which we say affect the individual's ability to perform the activities competently. So that's how the document is structured and that's how it's divided up.
If we look now, trying to get a bit of a sense from you about the competence statement, so if you've had a chance to look at it, if you could tell us, do you think the competence statement captures all the core activities a solicitor should be able to do? So that's our next question. It's, do you think the competence statement captures all the core activities a solicitor should be able to do? Okay, if we look at your results now, well, that's very encouraging. 83% of you are saying yes, and 17% are saying no. So that's very encouraging for us to see that there. If we're looking at now at those of you who are saying no, that it doesn't capture everything, we'd like to get a little bit of an idea about that. So it's a bit of a long question now. But those of you who said the competence statement does not capture all the core activities a solicitor should be able to do, what are the most important gaps, omissions, related to? So we've got number 1, ethics, professionalism and judgment. Number 2, technical legal practice. Number 3, managing yourself and your work. 4, working with other people. And 5, is there something else that's missing that's not listed there? So just give you that bit of a chance to look at that again. Those of you who said that the competence statement does not capture all the core activities a solicitor should be able to do, what are the most important gaps and omissions related to. Okay, we'll have a look at your responses now to that. Okay, so we've had a few responses there. The main area where people are saying that there are some gaps is looking at technical legal practice. Oops, it's come through there. So the main areas where we're getting responses there are looking at saying it's something else. So that's something for us to explore, and if you get the chance towards the end when we've got more open boxes, you can tell us what those might be. But some of you are saying that there's some gaps in ethics and professional practice and judgment. Technical legal practice, that is coming, that there are some gaps there too. Less so working with other people. Nobody's saying there's any gaps in that particular part. Managing yourself and your work, that's a little bit more, about 15% of you saying there needs to be some work there. Okay?
Okay, well, that's very interesting. Thank you very much for those views. And as Mary says, in particular in relation to something else, or if you need, if you wish to expand upon your responses to that question, then by all means, ping a question through or a comment through at the end of the webinar, and that will be very interesting for us to read. So, moving on, I said that the competence statement was intended to capture core activities. Now, of course, for a solicitor, their legal knowledge is important, and when we decided to move to the activity-based model for our competence statement, that did create a problem for us so far as legal knowledge is concerned, because legal knowledge is not an activity. So our approach to this was to say not what legal knowledge a practitioner must have, but to say what they need to do with it. So we have got a competence in the competence statement, which is all about what a competent practitioner needs to be able to do with their legal knowledge, and it's competence A4 for those of you who've got your the competence statement in front of you, but it's also repeated on the slide which we've got up at the moment. So what we say is that it's about using your legal knowledge to identify the relevant legal principles and apply the legal principles to the particular facts so as to produce a solution for your client. What we do not do is we do not anywhere seek to specify the particular legal knowledge which is required for specialist practice. It seems to us that that would be a complete hiding to nothing, that specialist practitioners working in a particular area of practice need to know what it is they need to know in order to practice safely in that area. So we haven't said, for example, if you're a shitting lawyer, this is the list of law that you need to know. If you're a banking lawyer, this is what you need to know. If you're a family practitioner, this is what you need to know. We haven't sought anywhere to specify lists of law for particular areas of practice. However, what we did pick up from both the clients that we spoke to and indeed the solicitors was a very firm and clear view that part of being a solicitor is the wide training that you have had and therefore a broader background knowledge of core areas, so that if you are working in a particular area, you don't just know you're not just able to deal with issues in that particular area, but you're able to deal with issues in the periphery around that area. Somebody said, for example, this is the difference between going to see a licensed conveyancer and going to a conveyancing solicitor, who you might expect is able to pick up a broader range of issues because of their more broadly based training. And so we have tried to specify, to identify and to specify a broad base of legal knowledge, which we say all practitioners need to be able to draw on and have a background awareness of, to shed light around the particular area of practice where they work. And we have specified that in a footnote to section A4 in the competence statement. and we have expanded it into the Statement of Underpinning Legal Knowledge, which is one of the documents attached to the consultation. I've put up on the overhead the legal knowledge which we say is core to practice as a solicitor. So this is what we say solicitors need to carry with them throughout their professional career, a background awareness of these core areas of knowledge. It may be that they're not specialists in these areas. It may be that all they can do is they can spot that there is an issue here. They don't necessarily know what the answer is. It may be that all they're able to do is to go to talk to somebody else who is a specialist in that area and can give them the answer. But they have an awareness, and that term we used very deliberately, they have an awareness of these issues so that they can spot that there is a question that needs to be answered.
Okay, and so if we look now at our next question, we've got 3 options there. It's to do with the knowledge statement. Does the knowledge statement capture the core areas of law solicitors need to know? And our 3 options there are, yes, it captures the core areas of law solicitors need to know. No, it doesn't capture enough of the areas of law that solicitors need to know. No, it refers to too many areas of law, including some that solicitors do not need to know. So getting your views on that, does the knowledge statement capture the core areas of law solicitors need to know? So I'll give you a couple of seconds of that before we look at the results. Okay, if we look at those now, and we'll see what people say. Okay, so that's very helpful. We see that 2/3 of you, 66%, saying yes, it captures the core areas that solicitors need to know. Then we have just over a quarter, 26.4% of you saying that it's capturing too many areas of law, and then 7.5% are saying it doesn't capture enough of the areas. So that's really helpful. So 2/3 of you saying it does capture the core areas.
So thank you for those views. Moving on now to the 3rd document which we're consulting on. This is a document we've called the Threshold Standard. As I said earlier in this presentation, the competence statement itself has no level specified in it. It applies both to solicitors at point of qualification and to those who have many years of experience under their belt. However, one of the things we want to do with the competence statement is to assess that intending solicitors can demonstrate that they meet the requirements of the competence statement. And in order to do that, we need to define the standard which we expect of them at point of qualification. And of course, we recognise that solicitors continue to develop post-qualification so that people become more expert, more experienced as they progress through their career. So what we tried to do in the threshold statement standard was to identify what we could reasonably expect somebody at point of qualification to be able to do. And so the threshold standard sets out a number of factors, things like the level of complexity of somebody's work, the extent to which they can work independently without supervision, and so on. If you take a brief look at the threshold standard, it's divided into 5 levels, and we've set the threshold standard required at qualification at level 3. And I should clarify that the reason that we have set out in the document all 5 levels is simply because we think it sheds light on the meaning of level 3. We do not intend to assess any of the other levels. As I say, we simply think that it helps explain what we mean by level 3. So again, we developed this through workshops, and we have tested it already through an online survey. And as I've said on this slide, which we're displaying at the moment, 78% of respondents rated it at 7 or above in terms of a rating on a 10-point scale, where 1 was low and 10 was high. So again, we had a reasonably good level of support for that being the proper threshold that we should expect of individuals at point of qualification.
Okay, so looking at that, we'd like to get your views about that threshold standard. Does the threshold standard accurately describe the level required for initial qualification? So if you could have a look at that level 3 that Julie's just described, does the threshold standard accurately describe the level required for initial qualification? Okay, we'll look at those results now. Okay, so that's very helpful there. That 73% of you are saying yes, it's set at the right level. We've got splits, and even split then between the other two, that just around 13% saying it's too high and around 13% are saying too low. So thank you for that.
So that's all very, very helpful. Thank you very much for expressing those views on your views on those documents. That's very interesting to us, and there will, as I say, be an opportunity in a moment for those of you who have questions or who want to make comments to express those to us. Before we get to questions, though, I thought it would be helpful to take a moment or two just to explain what the regulatory status will be, or what we intend to do with the competence statement subject to the outcome of this consultation. I said at the start of this presentation that the competence statement has two functions. It has a function so far as practicing solicitors are concerned, and it has a function so far as intending solicitors are concerned. So far as practicing solicitors are concerned, the competence statement connects to our work around continuing competence. As many of you may know, we have earlier this year proposed a new approach to continuing competence for practicing solicitors, where we expect practicing solicitors to maintain a proper standard of work as required under Rule 5, and to reflect on their work in order to check whether it is of a proper standard. What we expect is that they will check that their work is of the required standard by reference to the categories set out in the competence statement. So that's how these two pieces of work really come together. So subject to the outcome of our consultation, we will introduce the competence statement for practicing solicitors on the 1st of April 2015, when we will have a reissue of the handbook. And we will amend the notes to Rule 5. To repeat, the Rule 5 is the requirement to provide a proper standard of service, and we'll amend the notes to that rule to make clear that for practicing solicitors, compliance with Rule 5 means that a solicitor must adhere to the provisions of the competence statement. So that's how the competence statement connects to Principle 5 and the new approach to continuing competence. However, so far as initial qualification is concerned, we have more work to do. Again, as I said at the start of this presentation, what we need to do next is to design and reflect on how we are going to assess the competence statement upon admission as a solicitor. We have said in the consultation paper that we have a lot of work to do about that. We're going to take the next 12 months or so to do that work, and we will issue another consultation about that at the end of 2015. So until we get to this point of understanding how we are going to assess the competence statement at point of qualification, solicitors will continue, or intending solicitors will continue to work through our existing framework. So our existing requirements for qualification will continue to be what controls and guides and structures the pathway to qualification for solicitors at the moment. We will introduce the competence statement so far as intending solicitors are concerned when the new assessment framework is introduced. We have set out in our consultation paper where we've got to at the moment in terms of our thinking around possible assessment, the possible assessment framework. What we've said is that we've identified in broad terms 3 alternatives, 3 ways in which we could use the competence statement to assess competence at point of qualification. The first of those is that we could take the existing 3 stages, the academic stage, the professional stage, and the work-based stage. We could keep those intact, and we could use the competence statement simply so we could tweak the curriculum slightly so it reflects the demands of the competence statement. So we could take that and we could just simply slightly tweak the requirements on the way through so that those courses and those prescribed stages of training reflected the demands of the competence statement. We should add there that, of course, that's one particular pathway to qualification. Another pathway to qualification, which we're developing at the moment, is the new apprenticeship route to qualification, and that would also need to be assessed by reference to the competence statement. So that's the first option, that we take current pathways that we already accept, and we use those to teach and for candidates to learn what's necessary in order for them to meet the competence statement. Our second option is to assess the competence statement through a new professional qualification which people would take at point of qualification. So this would be a new test that we would design, which would be intended to give people an opportunity to demonstrate that they had the competencies set out in the competence statement. Now, as I say in the slide, there are 2 options for this. We could have prerequisites, so we could say that you're only eligible to take the professional assessment if you have previously completed particular courses or a particular pathway or had a particular experience of practice. Or we could say that because our focus was on assessment, not learning, that we would assess people through the point of qualification assessment instead of specifying prerequisites. So that would be an option for us. And the third option is that education training providers could be free to develop whatever programs they think were best suited to enable students to meet the competence statement. And we would then validate them or authorise them on the basis that we believed their programs were an effective mechanism to deliver the competencies required by the competence statement. Now, each of those have different pluses and minuses. The advantage of option 1 is that it would be relatively straightforward. The current pathways are well understood and well known. It would take relatively little work just to amend the requirements of the existing pathways to meet the demands of the competence statement. But a disadvantage is that it would still involve us in being prescriptive about pathways, and we know that there are issues around those pathways effectively then constituting barriers which prevent people who have the aptitude to be good solicitors from qualifying. The second option has the advantage from a regulatory point of view that if all comers are taking the same qualification that we specify, that provides us with a high level of reassurance about consistency. So we know that everybody's being assessed consistently and fairly. On the other hand, there will be a lot of work involved in developing the assessment, and we need to make sure that whatever assessment we choose validly tests the competencies set out in the competence statement. A simple knowledge test or a return to the Law Society finals type assessment, which was a memory test, would not be desirable because it would not test the competencies that we have specified in the competence statement. The third option probably gives the greatest degree of flexibility and might promote the most innovation, but it provides the most challenge in terms of us being able to assess all these different programs on a consistent basis. So it provides a challenge to us around the reliability of that option. When we come to look at these different options, we'll be assessing them by reference to these sorts of criteria. How valid are they? To what extent do these assessment options really test what is required in the competence statement? How reliable are they? How consistent are they? How robust are they? How rigorous are they? How fair are they? Do they impact unfairly on particular groups of candidates? How feasible are they? What's the cost involved in developing them? And to what extent do they create flexibility of routes? As I say, it's not flexibility around standards, but it's flexibility around routes or pathways to reach those particular standards. So just to recap, in terms of the timetable, the current consultation will close on the 12th of January 2015, and then on the 1st of April 2015, we will publish a revised version of our handbook, which will include publication of the final competence statement, of course subject to the outcome of the consultation, and that will be part of our new approach to continuing competence. At the end of 2015, we will go out to a further consultation on the framework for a new solicitor's qualification. Current pathways to qualification will be recognised until at least academic year 2017 to 18. We do recognise that there is some concern over transitional arrangements, both from the part of education training providers and also from those of you who are offering training contracts. So we will undertake as early as possible a piece of work around that to let people know what the transition arrangements will be and how long we will recognise the current pathway. But clearly a core objective of that piece of work will be to ensure that people who have embarked down a particular pathway are able to complete that pathway and are not disadvantaged by the introduction of new pathways. So we will want to make sure that people can complete and they're not left high and dry partway through a pathway and that they have to then go back to the beginning. That would not be a desirable outcome from us. But I hope we will get something out to you on that as soon as possible. So I think we then move to our final question before there's an opportunity for you to submit questions to us.
So now we've given you a summary, we just find it helpful to get a sense of how helpful you found this webinar at this stage. So we'd like to know, are you more informed about our proposed plans to ensure solicitor competence? So yes, you are, no, not, and you can also answer still got questions. So if you have a little bit of think about that, and then we'll get the results. Okay, we'll get the results now. Well, that's really helpful to see that almost 90% of you are saying, yes, you're better informed now. There's about 10% of you still saying that you've got some questions and a couple thinking they probably need some more information. So that's really helpful, thank you. So it's over to you now, Liz.
So now you have an opportunity to put in some questions to us, which we're very happy to consider. So please do click the question button and we'll see what comes through. What I suggest is that we take about a 2-minute break for you to think about the questions you might want to put in and for us to review the questions that are coming through. So we'll go offline for a couple of minutes while we review those questions. If you want to step away from your computer, get a drink of water, whatever you do, now would be a good time to do it. So I'm going to go offline now and we'll come back online in a couple of minutes' time. Thank you very much. So thank you, everybody. Some of the questions have come back in now, some interesting questions being asked. So the first question is a question about whether we're effectively suggesting a move from the LPC to a test like the New York Bar. Very interesting question. Of course, the New York Bar is exactly a centralised assessment set by the profession in that case in order to test competence centrally. So it does provide a high level of consistency. So I think what we would say about that is it has some advantages for us, that model, in terms of consistency, but what we would want to see is a test which was perhaps a little bit more like our Qualified Lawyers Transfer Scheme test, which included elements both of knowledge and skills. So our Qualified Lawyers Transfer Scheme test requires candidates to undertake role plays around legal research, drafting documents, doing a piece of writing, conducting a client interview, so that candidates have the opportunity to demonstrate that they can undertake the activities which we have identified, or something like the activities which we have identified in the competence statement. Somebody's also asked about whether we are keeping training contracts, and I think we are picking up that a lot of people value the experience of a training contract very highly, and that the profession in particular thinks it's a very valuable way of trainee solicitors learning the necessary skills that are required for practice as a solicitor. It's something that we want to feed into our evaluation over the coming year, so we want to have a look very carefully at the experience of practice. What is its value? What is it that it contributes? Is there a place for it as part of the assessment framework? So might we include an element of assessment of workplace experience as part of our work around designing an assessment for solicitors, or under option 1, certainly, if we kept the existing pathways, it would stay. But even if we moved to some sort of professional point of qualification assessment, that doesn't mean to say that there is no place for it requiring experience of practice. That's something that I think we'd like to do some more work around. Somebody has asked about the costs for validation of competence, and that's certainly another issue that we need to look at very carefully. We are aware that if we were to introduce a centralised point of qualification assessment, there would be a cost associated with that. Now, it might be that there were some cost savings along the way, because it might be that that would enable us to stop requiring something like the legal practice course, which might then create, which might save costs. So there might be cost savings on the one hand, but there might also be additional costs to pay for. So we're aware of that issue. We want to do a little bit more work around that to make sure that we avoid the trap, if you like, of designing a point of qualification assessment where the cost itself created an unjustifiable barrier. Let me just look at some of the other questions. Somebody has said, presumably you'll stagger the introduction of the competency framework for those that are part way. Yes, that goes to the point I was making at the end of the presentation, that we need to do some work around transitional arrangements for introducing all of this. So really good questions, really interesting questions, questions that form part of our programme of work over the coming 12 months. And that I hope we will be able to answer perhaps in the second of our consultations around the competence statement, when we are able to go out with some firm proposals about how we might assess it. There are some questions also about the relationship with CPD. Can you just scroll up, Mary? There's a question around 16 hours CPD. So somebody has asked, even though the 16-hour CPD is no longer being required, do we still expect law firms to keep records? And what we would say in relation to that is we don't prescribe how you keep a record, and we wouldn't specify the form in which that would take. But yes, our approach to continuing competence is that because it's a regulatory requirement to provide a proper standard of work to your clients, if something goes wrong, and if we were to come knocking at your door to say, well, hang on, this isn't competent, what have you been doing to maintain your competence, we would expect solicitors to be able to demonstrate to us how they have reflected on their work, whether they've identified any particular training needs, and what they have done about those training needs. So yes, keeping some form of record so you can demonstrate that you have been continuing to think about competence, that you have taken steps to address any learning needs that you have identified would be important. And I think there's another question on CPD. Somebody has asked about when the toolkit is going to be made available. So somebody has picked up the fact that we are providing some support for firms moving to the new approach to CPD in the form of what we call a toolkit of resources. That will be made available in spring next year, but before the competence statement is introduced, subject to the outcome of this consultation. Anything else? I think we've got a number of questions about, so what's this? Would one possible career path then become a law degree followed by 12 months work as a legal assistant? I think the answer to somebody's asked a question about, they've identified a particular pathway. They said, would a particular pathway be a law degree and then 12 months experience? And I think what I would say about that is that if we were to adopt the approach of specifying a centralised assessment, the question would have to be, would that give you everything that you need in order to be able to demonstrate that you have the competences? So what had you studied on your law degree? Where would what is at the moment covered in the LPC, where would that belong? If that were integrated into a law degree, it may be that you had captured all those elements. Where would you have picked up the skills required for practice? And would you be in a position after 12 months to practice to the standard required by our competence statement, by our threshold standard, the competencies set out in the competence statement? So if we took one of our options, it would be for individuals concerned to take a view about whether they were ready to attempt the point of qualification assessment, and if they were, then they would present themselves for assessment. If they believed that they had developed the necessary skills and the necessary areas of knowledge. Is there any other questions? Quite a lot of questions are coming through. So what is the earliest that we envisage solicitor apprenticeships being introduced? The introduction of solicitor apprenticeships is being driven by a different timetable, which is set by government rather than by ourselves. So we are working at the moment with a group of employers, subject to the outcome of all of our consultation processes around the competence statement, that the standard for qualification as a solicitor will match what we're setting out in the competence statement. And that approach has already been approved by the Department of Business Innovation and Skills. They're requiring us to put in an assessment model, an assessment plan in spring 2015. If that is accepted by the Department for Business Innovation and Skills, then it may be that we see those pathway to qualification coming through by September 2016. So I think there were also some detailed questions about the webinar and about the materials and available. So there are the slides will be available to everybody in the resources page. All you need to do is, if you go down to the resources page, the slides are available there, and you can keep those, you can download them, and the webinar will be available on our website. So there'll be a link to the webinar if you want to go and listen to it again. So that, I think those were a couple of questions that we had picked up.
I think that's everything covered there.
I think that's just about it. We haven't. There may be one or two questions that we haven't addressed. If we haven't addressed them, the questions now, we're very happy to go back to you individually to answer your questions on a one-to-one basis. So I think that covers it. Yeah. So thank you very much indeed for listening. Thank you very much for expressing your views. They're very important to us, and can I urge you to, if you haven't already done so, to take a look at the consultation paper and to put in a response to the consultation by the 12th of January. We do have a very short exit survey. Again, you can find this if you click the resources tab. It's very short about your experience of this webinar today, and to give you an opportunity to make suggestions for future webinar topics. So can I urge you to take a look at that and complete that. So once again, thank you very much indeed for listening, and goodbye.